This is the Parliament Channel and Parliament Radio 105.5 FM.
The Honorable Deputy Speaker.
As we resume, member for St. Augustine, you have 6 minutes of your initial time. And do you care to avail yourself of the additional 15 one time? Proceed.
Mr. Speaker, when we took the break, my dear friend from Aruka asked if I was going to answer the question in relation to the right of every citizen, including herself, under 4C of our Constitution that reads, "It is hereby recognized and declared that in Trinidad and Tobago they have existed and shall continue to exist without discrimination by reason of race, origin, color, religion, or sex, the following fundamental human rights and freedoms, namely," and at C, the right of the individual to respect for his private and family life. Of course, the Constitution is to be liberally interpreted. And I'm sure when my friend had her difficulties with the bank account, and there was a lot of public interest as a source of funding, and so I could only imagine the human turmoil that she would have held in her heart and in her family. Yes, yes. So that you have a personal experience about the intrusion in one's private life. And I expect only the highest caliber and the conduct from a friend from Aruka. And therefore, I am not one to presume guilt. I presume innocence that the Constitution requires me to do. So that is a classic example of how things, encroachment into your private life, but we in public life. So your private, public life, there's a big distinction between that and the average citizen for whom I speak here today. Once you put yourself into public life, there are different criteria and a different standard to be adhered to. Different expectations that you should be as transparent as you possibly could. But we're not talking about ourselves. We don't make laws for ourselves. We make law for all of Trinidad and Tobago. So in answer to the brilliant member from Barataria, yes, it does affect that right. But getting back into the actual legislative intrusion, 2E says, Mr. Speaker, nothing in this section shall be construed as requiring any person to give any information which may incriminate him. This is a catch-all band-aid to put over a festering sore of all that came before it. Because all the law read above speaks now to the incredible power now to be given for you to give information. And I want to say this, there will be many occasions when a person may be answering questions in the best of faith without proper legal advice, appreciating that he could be incriminating himself in an offense. Because there's so many different complex laws that have come that what we would have taken as granted that we could do, we can no longer do. And the population very often is unaware of many of the legislative change that has made practice criminal. And the law says ignorance of the law is no excuse. So that this authority now being granted to request all this information, you know what I am struck by? That nowhere here says that they may do so only if you're a suspect, because the law has checks and balances. If they have suspected you of committing an offense, then they must tell you as they approach you, you have the right to remain silent. Anything you say may be taken in writing and may be used in evidence against you. That is a cold, chilling statement. When you hear it, it awakens you to the enormity of what may be before you. But this thing is like a thief cloaked in priest's frock, coming as if to do you well, but to require from you information that they may be building a case against you, and there is no requirement under this procedural provision anywhere here to say that they have to caution you in advance. And that, member for Laventille West, you appreciate that more than anybody else. The need for caution. Because it is law, not just written in our Constitution, at section 5(2)(d), which says, Mr. Speaker, with your leave, except as is otherwise expressly provided in this chapter and in section 54, no law may abrogate, abridge, or infringe or authorize the abrogation, abridgment, or infringement of any of the rights and freedoms hereinbefore recognized and declared. And at D, under 2, it says, without prejudice to subsection 1, but subject to this chapter and to section 54, Parliament, that is us here, may not authorize a court, tribunal, commission, board, or other authority to compel a person to give evidence unless he's afforded protection against self-incrimination and, when necessary, to ensure such protection, the right to legal representation. That is as clear as it comes. And if there is doubt about it, our local court of appeal in the case of Hayden Tony against P.C. Joseph Coraspi is a ministerial appeal, number 68 of 2008. Justice of Appeal Barrow said this: the right of silence and privilege against self-incrimination form part of the due process provisions set out in section 4A and the right to the protection of the law set out in 4B. If we are to enjoy these continued rights, as is noted at 2A, I beg your pardon, at 2E, then we are making a mockery, because you are not required here to inform a person that they may be a suspect, that there are criminal investigations in progress, and you may freely give information at the end of which you, having not been cautioned, can be used against you, and then you talk about, I am not required to say anything that may incriminate me. But look at the inconsistency in logic that we are faced with. These are magisterial issues to be determined by a magistrate in terms of willful obstruction. But the issue of the right against self-incrimination is a constitutional matter which cannot rightly be provoked before the very magistrate. Any constitutional issue is to be determined by the High Court. Absolutely. So that you will have a criminal prosecution in progress for willful obstruction, and unless you have the resources or wherewithal, or even competent counsel to tell you, listen, what has happened here is an infringement of your right against self-incrimination, and the evidence that now being produced, you haven't not been cautioned, you haven't given evidence, will then now become a constitutional matter to be determined by the High Court. So then you create a logjam of constitutional issues to be determined. Of course, Member for Laventille West.
Thank you very much. Is the member suggesting that we legislate need for police caution?
I can see no harm in it. You want?
Could you cite any previous legislation? Yes.
Even though, yeah.
Yes, I wish to direct to my friend the question whether he could cite any precedent in any legislation where we legislated the need for police caution in circumstances such as that.
Yeah. And there is the dangerous mindset of the learned friends. If there is no precedent, then this is unprecedented. And this is a conundrum. I've given more than sufficiently.
Yes.
So I have to be a little stingy with my limited time now, sir. Yeah. So thank you very much. It's Christmas time. Toys are coming soon, don't worry. Yeah. Now, the long and short of it is,
What you want up there?
they now put this catch-all to say that you have the right against self-incrimination, but everything above it says that you are required under the penalty of law to give information, to give evidence, to give statements without a caution. So my friend unwittingly may have touched something that is necessary, that in circumstances such as these, where there's an ongoing investigation, unless there is no investigation, if there's no investigation, why do you wish to have this information? So it's a catch-22, right? Where, for instance, which comes first? Do you now go and cast your net as wide as you could, and then at the end of which filter through and see if there's a criminality there, and you unwittingly contribute without exercising your right against self-incrimination? This is why, so flippantly we hear that the opposition is not willing to support. That is not true. The position, as I've heard it from every member thus far, is joint select so that we get better law, and the history has proven. I said, what? Less speed and more haste? Yeah. Whatever it is. There's all wisdom in taking your time when you go into issues of constitutional intrusions. So this is very, very important. As much as it may be useful and helpful in a police state to have this sort of power, this is Trinidad and Tobago, where our liberty is loved and we are willing to stand up for it. It is easy now to cast the evil and speak of corruption, to speak of who've done what, but in that effort to deal with it, you cannot go to the other extreme. You cannot. That is why you have a parliament, to ensure that there's balance in legislative change. Because when you're in power, oh boy, how sweet it is. Because you believe that you make law for everybody else. That may be true. But I have been there, we have been there, and you realize there's an installation that comes. And we've seen them no more dramatic installation from the present government and from the people than in this last 2.5 years. Suddenly, language change, and we have it on both sides. That is how the politics works sometimes. But rest assured that nobody is saying we don't want to support law to deal with corruption, because we're not saying that alone. We did it in our time with procurement. When we started the work, and I was so happy having demitted office, not to have been happy to have demitted office as much, but to have heard the Prime Minister and my friend from Port of Spain North speak about campaign and party finance reform legislation being high on the agenda. Well, I don't know how high is, but I thought high means first, and everything else come after. We're not seeing that. But I digress. We move forward. There is so much impracticality in this thing. This requirement, Mr. Speaker, of having importers keep records for many years sounds good, but how useless is that? We cannot, at the altar of incompetence or at the altar of inefficiency, say that you will be investigating things 5-6 years down the line, and then call upon me to produce documents and say if I don't produce it, there's a criminal penalty for that. Maybe my friends have forgotten, with the very valiant efforts of the former Minister of Trade, Mr. Vasant Barrett, when we, and with the direction of the Prime Minister, Kamala Prasad Bisesa, and with the Cabinet's confirmation of it, to push forward the executor system. You know what that is? It dramatically changed the way custom operates. That whenever you import, I'm sure the member for Aruka knows about this, because it is one of the gems that as much dirt they want to put on the partnership, they don't want people to realize the dramatic difference it has made in the way business is done in terms of importation.
Yes, yes.
All documents. No, I'm saying that we participated in making it happen. Sorry, yeah.
I sure you are aware of the procedure, please.
And it's right. We didn't create it, but we knew it was there. They talk about it and we implemented it.
Yes.
Talk is cheap, action is rare.
Yeah.
So, what that does, Mr. Speaker, and I'm no expert on this, I'm learning as I proceed, that all documents relevant to the importation is electronically loaded in.
Prior.
So that you don't have this thing about you have to go to the wharf and go and get this document stamp, and then go by this other office, and then go and get this other approval, and it takes you days, sometimes weeks to get a simple shipment done when it could all be done electronically.
Single.
Red tape, as we said, from the red tape to the red carpet. Single electronic window and a host of other things. But it's not for me to campaign here, but try to speak the truth on what happened. So this issue of documentation is no longer relevant. And I spoke to one of the finest lawyers in the country, especially in evidential matters, Mr. Jack Singh, this morning, and he says to me, look, that's the old-time thing, this thing about documentation. Under the Evidence Act, we do not even need original documents to prove a lot of cases. So why is it not on the state, which already requires you to put all of the documentation in the system electronically, to rely on that? But they put the burden now on an importer. It sounds like no big deal to keep documents. But if you're living in Central and South and you know the kind of flood, and you hear a flood come and wash out all your documents, and then they call upon you to produce it and you can't, criminal prosecution? I've given real-world examples of this thing. Has the Attorney General spoken to anybody outside of the ministry to decide if this legislation has practical, reasonable capacity to be successful? No. Where is the consultation when we were told, let's do this together? Did we speak to the Law Association? No. Did we speak to the business groups? Did we speak to the Comptroller of Customs? I am sure, maybe. Did we speak to the judiciary? Did we speak to the DPP on these matters? Or are we just shooting into the air, a flare? Everybody looks up and says, wow, something has been done, but it's been shot into water and not hitting a target. That is the point. So the issue now, and there's another very mischievous thing in this, Mr. Speaker, as my time moves very quickly along, at this one, at 2B, where an importer receives notice of an adjustment. Note that, in accordance with subsection 2A, which results in further duties or taxes being payable, and the importer or consignee fails to commence proceedings before the appeal board within 6 months from the date he received notice of the adjustment, the comptroller may refuse entry or delivery of subsequent shipment of the importer or consignee who has not paid the adjustment, in addition to commencing proceedings under section 246 for the recovery of same. What is the practical effect of this? Mr. Speaker, we are coming years after. And I say we, the state of Trinidad and Tobago, to tell an importer, look, we've reassessed you. We've readjusted how much duty you have to pay. And you have to pay so much more than you paid 4, 5, 6 years ago. And that if you do, no, I want to hear, if that is not the situation, I'll be grateful to hear it. But if it is, what of a situation where many importers are companies and there's an assessment on a consignment that 4 or 5 years after there's an adjustment? The company is an importing company. They didn't import it for themselves, and for whatever reason, they are seen as the importer on the documentation. And if they do not go to the tax appeal board within 6 months, then the Comptroller of Customs has the authority. You bring in goods 4 years after, somebody else won member for Laventer lease, and they seize that. Think about that. You had nothing to do with what happened 4 years ago. but your goods get seized because of some error, some mistake, maybe even some fraud that occurred some years before. Remember for Moruga Tableland, they seized your goods. You had nothing to do with this. Could there not be great mischief afoot to destroy certain businesses and allow others to prosper? These are the things that we are very, very troubled by. Where in the world do we have this capacity to not understand the real world effects of a company that may have changed ownership during that period of time, but yet carry responsibility and liability for which you may not have a record? The company has a life of its own, and every share member has changed, every director has changed. But because, yes, thank you very much. Exactly. So these are the things that trouble us much, and I could see no real harm in echoing the call for a joint select, because we want to make this thing happen. I too believe that we need to be rid of corruption. I want a country that says progress, not protest. I want a country that says construct, not obstruct. I want a country that says decency, not thievery. And you know, the sanctimonious holiness that some of my friends speak with, that they know everything. Oh, thank you very much, Mr. Speaker. Look, a most painful and grievous and hurtful occasion occurred here earlier today, when my dear friend from Chaguanas West was referenced that he was not here, and the most insidious and awful interpretations of his absence was given. I am grieved to tell you, Mr. Speaker, that Mr. Ganga Singh's father died this afternoon. And he was in the hospital. But there it is easy to say,
Yes.
to apportion that his absence was as a result of the debate before us. And I know he didn't intend it. And that is the most dangerous of things. Because when you didn't know, you don't know, but you assume the worst, presumption of guilt on everybody else. And that is a clear example why you could not give more power. No another thing, Mr. Speaker, I thank you.
Leader of Government Business.
Thank you very kindly. Mr. Deputy Speaker, in accordance with Standing Order 53, I beg to move that this debate be adjourned. Yes. Shall I repeat, sir? They're not listening. Yeah, I think they're not listening.
Leader of Government Business.
Thank you again. Mr. Deputy Speaker, in accordance with Standing Order 53, I beg to move that this debate be now adjourned.
Honorable members, as requested by the Leader of Government Business, this debate is now adjourned. However, you would recall that earlier in today's proceedings, honorable members, the question is that this debate be adjourned. All in favor, say aye. Aye. Those against, the ayes have it. This debate is now adjourned. Honorable members, you would recall that earlier in today's proceedings, there was an agreement between both sides of the House to introduce a bill later in today's proceedings. I now revert to the introduction of the bills and call upon the clerk.
On the second supplemental order paper, the Finance Bill 2017 by the Minister of Finance.
Leader of the House.
Thank you very kindly, Mr. Deputy Speaker. Mr. Deputy Speaker, I beg to move that this House to now adjourn to Wednesday, the 6th day of December 2017 at 10 a.m., at which time we will be doing the anti-gang bill. Deputy Speaker, we will be taking the bill through all its stages on that day, on Wednesday, the 6th of December. We did that already.
Honorable members, there are two matters that qualify to be raised on the motion for the adjournment of this House. However, one of the motion has been deferred by agreement to the next sitting of the House. I now call upon the member for Caroni Central.
Thank you. Thank you very much, Mr. Speaker. The matter I wish to raise, Honorable Speaker, members of the House, citizens, is the urgent need for the Ministry of Education to address the safety of children and teachers because of the structural deficiencies of the Presal Government Primary School. I want to start by indicating some facts about that particular school. When I became the Member of Parliament for that area, what we had was a school that was about 80 years old, in which the children were housed, and construction of a new school which had been stopped, which had ceased. So we had a situation where the children were operating and the teachers in a dilapidated school, and there was the issue of delayed construction of the new school. We had sewer problems in the school, and we had a stench from the shower. I liaised with the minister, both in personal terms and in writing, and he did correct the matter. But after a while, what happened was that the stench returned again. We had the sewer problems again. And they were eventually fixed again, I want to say that, but there was a long delay. And frustration started to set in the school compound involving the teachers and the children, but more than that, the parents, who were very, very concerned because there were many days that the children would miss school, and that caused a problem and an inconvenience and hardship to everyone. In addition to that, it's an old school, and the situation was kind of stuffy in the school. You had a suffocating situation. I worked with the private sector in the area, and we were able to put fans in every classroom. But the fans, unfortunately, were not adequate to keep the school as cool as one would need to have a full day's classes. And there was a great deal of unhappiness in the school and a great deal of stress. The situation involved, the school sought to involve the supervisor for the area. The Parent Teachers Association of the school was, of course, involved. They involved the National Parent Teachers Association. And my approach was always to be supportive of the parents, the teachers, and the children without causing a commotion about the issue, because I did not really want to disrupt the education of the children. Now, the disruption of education for the children did cause a problem, because although the school got as many passes in SEA this time as they might have done before in percentage terms, the students of that school did not make it into many of the prestige schools this year, although that had been a tradition in which a reasonable percentage of them would have gotten into presentation and Holy Faith and so on in the surrounding area of central Trinidad. So it did have an academic cost. and perhaps a career cost to some of these children. And of course, that intensified the unhappiness. The other thing, there's no way I can show a causal effect on this, but the year before, the students had won the cricket competition nationally. This year, they made it to the finals, but they didn't win. And they are also good athletes in that school, and they do very, very well. But I think both the athletics and to some extent the cricket also suffered. So all I would like to ask the minister, I'm not here for a confrontation at all, and I just want to help the kids. I want to make things comfortable for them. It is something that I've raised with you before and I've written about. If I can get the assurance from the minister, there is now consensus, Parent Teachers Association, principals, staff, children, parents, that it would be more convenient to move to the community center in Prisal, which is not far away, which is air-conditioned and has ample room. And if it doesn't have ample room, we can perhaps address that issue at a later stage, but it is manageable, so that the children would be spared the suffocating situation in the school. And the second commitment, if I could get from him, as you know, the new school was scheduled for continuation in the last budget, and for various reasons it was not honored. And it is now in this budget, and I would like an early start for construction of the school. But I want to say the situation is exacerbated by the fact that there were minor problems with the walls of the school, and the Parent Teachers Association tried to get OSHA and the supervisor for the area for education and even the fire services to come and look at the school and do an official assessment of the school and what the state of the school was. That did not happen for whatever reason. I hope that it was not from a desire not to look realistically at what was happening at the school. And the parent teachers eventually got a report done by an engineer. I will be truthful, this is from the report of a civil engineer. It is not the report of a structural engineer. But it does contain photos, and I shared this document with the Minister of Education, so he will see for himself. And the indication of the report, without belaboring the issue, is that the pictures show a preponderance of vertical cracks that separate the walls from columns throughout the building. And it goes on to explain how the walls are constructed. And at the end, basically, they suggest that, look, it is possible that nothing may happen, but should an earthquake occur, it is almost inevitable that the walls will come down and the roof may crash. And in that situation, the teachers and the children will be endangered. So I ask the minister, please, in an amicable way, let us solve the problem for the children immediately. Let us move them to the community center with the consent of all the parties involved and with the blessings of the minister and Ministry of Education. And let us honor our promise to start the reconstruction of the new school, which has been basically delayed for some time, by at least a year, if not more, so that, one, we can house them comfortably, and two, within reasonable time, we can move them into the new building, which I'm sure that they are looking forward to and anticipating. So I ask the minister if he could respond positively, please. Thank you very much, Madam.
Minister of Education.
Thank you very much, Madam Speaker. Madam Speaker, I'm very happy to respond to the member for County Central. But in responding, let me first say that this motion, to my understanding, is predicated on the notion that the Ministry of Education is not taking care of our children, or that we are not aware of the safety of the students. Madam Speaker, let me begin by saying that the Education Act confers upon principals certain responsibilities, the foremost of which is the care of the students under his guidance. I can tell you, Madam Speaker, from the very beginning, that this ministry is doing everything to ensure the safety of the students at the Prakash Government Primary School, and we will continue to do so. The second point I wish to make is that the motion talks about the structural deficiencies. We at the Ministry of Education can only determine if a building is deficient structurally upon an engineer's report, and that engineer's report has to come from the chief design engineer at the Ministry of Works. That is the authority on which we rely. I am aware that the PTA commissioned an engineer to do a report on the school. And while that is fine, in fact, I commend the PTA for such action, we are constrained to follow the advice of the engineer from the Ministry of Works. We have written to the Ministry of Works asking for such an assessment to be done, and we are waiting that assessment. In the meanwhile, Madam Speaker, our officers will be visiting the school next week, Tuesday, to see for ourselves what can be done so that we can appease everyone, the parents, the teachers, and most of all, the students. We will be making an assessment also, pending the report from the chief engineer of the Ministry of Works. We are also looking at an area that has been mentioned by the member for County Central, and that is the community center. Again, we have to examine that to make sure that all the health and safety requirements are put in place before we can decant our students to that community center, and that is something that we will be paying attention to. So I want to assure the member for County Central that we are on board where this is concerned. We are not about to neglect our children. We are not about to trifle with the safety of our children. We will do everything to make sure everyone is comfortable. In case of the construction of a new school, I have informed the member for County Central on many occasions that we have listed a few schools that we will consider as priority. And the Prakash Government Primary School is one of those priority schools that we have listed. So as soon as funds become available, and as soon as we're in a position to carry out the construction of a number of new schools, the Prakash Government Primary School will be high up on that list. Thank you very much.
Honorable members, the question is that this House do now adjourn to Wednesday, December 6, 2017 at 10 a.m. All in favor say aye. Aye. Any against? The ayes have it. This House now stands adjourned to Wednesday, 6 December 2017 at 10 a.m. Sharon.